Good afternoon, everyone. Thank you again for joining us. This is now our fourth anti-money laundering webinar that Dugan George has hosted. My name is Amelia Ramsey and I'm a partner here at Dugan George Defence Lawyers. I'd like to welcome you all, and I'd also like to welcome today's speaker, Barrister Abilene Singh. Abilene practices in commercial litigation, proceeds of crime, both state and Commonwealth, and general crime for both defence and prosecution. Prior to coming to the bar, Abilene practiced in commercial litigation for a number of years and was then a senior solicitor at the OPP in its Proceeds of Crime Directorate. So she's well and truly experienced in the area to be delivering today's topic. Today's topic is an introduction to Victoria's Confiscation Act, focusing on charge or conviction based and civil forfeiture restraining orders, as well as the newer unexplained wealth restraining orders. I'll hand over to Abilene. Thank you.
Hi, everybody. I'll just start this presentation. Okay, hopefully you can all see my introduction page. So this is an introduction to the Confiscation Act 1997 Victorian legislation. It's quite a huge piece of legislation, so this is on some level quite a high level detail of the Confiscation Act, but hopefully it will elicit some discussion from you all at the end about some more specific topics. This is an overview of what we're discussing today. I'm going to move quite quickly through the slides because there are many of them. The first place to start with any act, and in particular with the Confiscation Act, which involves a lot of statutory interpretation, is the purposes and objects of the Act. And in this case, we're looking at sections 1 and 3A. I might just read you out a couple of the purposes. The purposes of the Act are to provide for the forfeiture of the proceeds of certain offences, to provide for automatic forfeiture, civil forfeiture, and forfeiture used in connection with the commission of certain crimes, to provide for freezing of assets and destruction or disposal of certain illegal goods, and to provide for the effective enforcement and management of seized and restrained assets. Its main objects are to deprive persons of the proceeds of certain offences and of tainted property, to deter persons from engaging in criminal activity, and to disrupt criminal activity and to undermine the profitability of serious criminal activity. And that just gives you a bit of a flavour about what the Act is about. At the outset, I draw practitioners always to the legislation and the various rules and practice notes. And I've set out there the Supreme Court rules and the County Court rules. Often it's difficult to find where the Confiscation Act rules in the Supreme Court and County Court rules lie. In the Supreme Court, it's in the criminal procedure, and County Court, it's miscellaneous. I'm also going to draw your attention in particular to Schedule 1 of the County Court miscellaneous rules, because that is where a lot of the pro forma forms for exclusion applications and any other applications, not all applications, but forms that you would ordinarily require to file an exclusion application or vary a restraining order, they are generally found in Schedule 1. So have a look there. There's also the confiscation regulations, and we've got practice notes in both the Supreme and County Court. Some important things to remember are that confiscation proceedings, whilst often born out of criminal or alleged criminal activity, they are civil proceedings. And that means the standard of proof is the civil standard, being the balance of probabilities. The civil evidence rules apply, and that's important for example, hearsay arguments, obviously being easier in civil proceedings than in criminal proceedings. And also there are cost consequences. The general rule in civil proceedings is that costs follow the event. There is also a specific provision in section 133 capital A of the Act that deals with costs. So this is an overview of the Confiscation Act. there are restraining orders, exclusion orders, but it's also important to note, if you're criminal law practitioners, that in the Confiscation Act, that's often where your forfeiture orders are found, pecuniary penalty orders and disposal orders. Confiscation Act also deals with freezing orders. Freezing orders are often made against financial institutions without anybody's knowledge to freeze assets before a restraining order is made. Often you might get a client come to you and say, I can't access my bank account, and they haven't been served with the restraining order. What might have happened is a freezing order has been made pending a restraining order being made in the courts ex parte. So it's a very preliminary step that can be undertaken. Search warrants are specifically provided for, as are examination orders. If you've been to Doug's earlier seminars, Christian Jubner probably spoke about examination orders in the Proceeds of Crime Act Commonwealth frame. Examination orders are also permissible in the state legislation, although rarely utilised, but the power is still there. There are other information gathering powers, such as production orders and search warrants for property tracking documents. I pause there to say that the importance of knowing about the other information gathering powers is that often you might get a restraining order with an affidavit in support, which might have, for example, documents from a conveyancer that the Victoria Police has issued a production order against in order to collate all the documents from a conveyancing firm relating to a property transaction. Or they've used other powers under mutual legislation, such as to ask the ATO for certain documents concerning income over a large period of time. So before the proceeding has even commenced and your client has been served with a restraining order, just be aware, and this is important for when you're taking instructions, that in fact the other side might already have a huge range of documents, financial documents and otherwise, against your client. And so it is important that when giving their version of events by way of affidavit, that it is true and correct and referable to documentation as far as they can say. And if they cannot provide exact instructions, you need to be clear in the affidavit material about that. So that's just an overview. Time limits. Time limits in Confiscation Act matters are absolutely critical. I have not restated what the time limits are for each and every situation here because that would take forever, but also every situation is different. The Supreme Court has very, very helpfully prepared a time limit guide, which is available at that website that you can see there, or you could just Google Supreme Court Summary of Relevant Time Limits, Confiscation Act. And it states in that document the various time limits for filing exclusion applications. And that's always important. That's the number one thing to obtain instructions about. When was the restraining order made? When were you served personally with a copy of that restraining order? Were you given notice of the making of the restraining order? Different time limits flow from different events depending on who you are. So that's very important. So there are some key definitions and concepts that I've already kind of spoken about very quickly, but the main concept is a restraining order. And a restraining order is, for the commercial lawyers out there, much like a Mariva injunction. It's a freezing order over assets to prevent disposal. And I think the Court of Appeal has described it as such recently as well. They're made in rem, that means as against the property itself and enforceable against the world at large. and not in personam against the individual. An example of an in personam order would be a pecuniary penalty order. A brief example being you're alleged to have trafficked in meth to the value of $1 million and you've obtained that benefit. $1 million pecuniary penalty order is made against you personally, whereas a restraining order is the restraint of property. Dealing with property is a criminal offence, and it's quite a broad concept what dealing means. But for example, for a house, for a real property, that could mean renting out the property. That could definitely mean selling the property, obtaining a new mortgage over the property, refinancing the property, potentially dealing with the offset account associated with that property. It's quite a broad concept and something to be wary of. Sometimes restraining orders are made in reliance on criminal charges or conviction, and other times they are not. And we're going to be speaking a little bit about when they're not today. Restraining orders are often based on this lesser form of proof. I believe X, Y, and Z, or even lesser, I suspect that property is not lawfully acquired. Suspicion is one of the lowest forms of proof. So, property. So property has a very broad definition under Section 3 of the Confiscation Act. And property means, let me grab the definition specifically for you. So property includes legal and equitable interest in property. And if I move straight to what interest in property means, let's do a quick search. So interest in property also has a very broad definition. Sorry, I'm moving back a bit all over the place. Apologies. Property is defined in Section 3 as meaning real or personal property of every description, whether situated within or outside of Victoria, and whether tangible or tangible, and includes any interest in any such real or personal property. So property could include cryptocurrency, arguably an intangible asset that exists outside of Australia, potentially exists everywhere and nowhere all at once. But cryptocurrency, and there has been restraining orders made against cryptocurrency, and there has been successful forfeitures of cryptocurrency, has been found to be property within the meaning of the Confiscation Act. Then we've got the idea of interest in property. And our understanding of interest in property might simply be a legal interest. You're the owner of a property, you're the registered proprietor, or an equitable interest, you hold a constructive trust in relation to the property, or an actual express trust. But interest in property in the Confiscation Act is actually an incredibly broad definition. And I'm going to read you out the definition quickly. It's the legal or equitable estate or interest in the property. That's a common sense approach that we would all appreciate. But this is the second bit. Or a right, power, or privilege over or in connection with the property. Now that is the broad, or what we call the lesser form of interest. And it is short of ownership. So what that lesser form of interest might include was explored by the court in the case that I've set out there. And you can have a read of that in your own time and have a look at specifically, I think I've said PB 96. I think it's page 96 potentially. But if I can read it quickly to you, a reading of the Act as a whole demonstrates that Parliament has intended to cast its net widely in defining the concept of interest in property. Secondly, the wide definition also gives persons who have some interest in the property, short of ownership, the right to apply for an exclusion order and thus avoid injustice from the harsh operation of the confiscation provisions of the Act. So that means the importance of looking at what the lesser form of interest encapsulates. And a good reminder to us practitioners is that a client may not have a true legal or equitable interest in the property, but they might fall within the scope of this lesser form of interest. It's important to note that not every case, though, attracts an interest. And what Justice Croucher said in the case of Taleb was, I doubt that a mere contractual right of a lender to sue a borrower for the repayment of funds advanced to buy property would amount to a right in connection with the property. Rather, I think that the connection between the right and the property must be more than coincidental to come within paragraph B. I was also recently involved in a case at the end of last year or middle of last year in the Supreme Court against state trustees who were trying to say that their client fell within this lesser form of interest in relation to the provision of funds that ended up being used to purchase a property. There was an argument that there was potentially a resulting trust or a constructive trust relating to the use of those funds, but essentially what was found was that you have to know what the property is in order to have an interest in it, and that there was no way that this could fall within the right, power, privilege in connection with the property. There has to be a nexus between potentially the funds and the property that is enough to attract this lesser form of interest. I've also referred here to effective control, which equates to interest, and I put the specific provisions and the pinpoint reference there for you to assist in finding the exact statement from Justice Kay about effective control. But that includes, His Honour said, things like being able to rent out a property and deal with the property in a way that an owner would. So that assists often the other side in showing that a real property where the registered proprietor is not the same as the accused, for example, in showing that an accused person has effective control of, for example, a property because he or she could rent it out or obtain a loan in respect of it or encumber it further or do certain things with the property. Tainted property, another concept. Tainted property relates to, and I'll read out the definition. So all the definitions are generally in Section 3 of the Act. And I'm just picking out some key terms. But tainted property has two definitions. It depends if it's civil forfeiture or not. This is or not. In any other case, property that in relation to an offence was used or was intended by the accused to be used in or in connection with the commission of the offence. So that refers to property that has actually been used or property that might be used in the future for an offence. So just consider that in the concept of a cannabis crop house where all of the accoutrements of the offending are there, but there's no crop there. But it looks like there is a crop that has been there of a commercial quantity. Potentially it could fall within the definition of was used in connection with an offence. So there are some 4 key takeaways here about what tainted property used in or in connection with might mean. But essentially it's a matter of fact and degree. And the Court of Appeal has found that there need not be any substantial use. In that case of Chalmers, the Court of Appeal talked about the use of a property to discuss a criminal enterprise, a meeting between people at a home, and then the carrying out of that enterprise later, whether or not that attracts the tainted property, and then the use of the property, a beam in the property to hang a person. Does that equate to tainted property? And essentially the first one, the Court of Appeal said it was a mere locus. So sometimes just because a crime might have been committed at or in connection with a property doesn't make it tainted property. Often there is an argument that it is a mere locus, a mere location. Recently, Justice of Appeal Taylor, Her Honour in the case of Basham, that the murder at Phillip Island, found in making a forfeiture order that the use of the garage, and I'll tell you specifically what Her Honour said, the track of the garage door of the home was used to hang Ms. Fraser, and that home had been restrained by the Director of Public Prosecutions. Her Honour said at paragraph 1550, I am satisfied that it, that is the Seagrove Way property, was used in connection with the murder Basham committed on 23 July 2018. Indeed, it was instrumental to it. The track of the garage door was used to hang Ms. Fraser. Part of a house used to support a rope to hang a victim was the very example given by the court in Chalmers to illustrate how real property could be deployed in the commission of an offence. That alone is sufficient. So that's a way in which murder, which is a Schedule 1 offence, was the relevant offence that tainted this property and equated to a forfeiture order. I have some other definitions here that I'm going to very quickly run through because I'm already 22 minutes in and not even at the various restraining orders. But there's derived property, which is a lesser form of tainted property, but still an important concept. Automatic forfeiture, have a look at section 35. I think I'll speak about that a bit more in a second. Forfeiture, exclusion applications. In relation to exclusion applications, I understand my colleague Eli Fryer will be speaking in a few weeks about exclusion applications as part of Doogs' series. So listen out for that. But it is important to note the timelines that I referred to earlier, and when ascertaining if somebody has any prospects of an exclusion application, the importance of taking fulsome instructions, and also looking again at what interest in property they are asserting to have, having regard to the lesser form of interest, and also having regard to the fact that they need to prove their case by way of affidavit material and by reference to express documentary evidence, evidencing each and every transaction that they can possibly evidence, that the other side might already have a bevy of documents against them. And I just wanted to remind everyone about Schedule 2 offences, which are relevant for charge-based restraining orders, and just a quick reminder about simpliciter offences. For example, usually we all say traffic commercial quantity or cultivate commercial quantity. Immediately it's understood that they are automatic forfeiture offences. I think it's a good reminder to note that Part 3 of Schedule 11 of the Drugs, Poisons and Controlled Substances Act has a column stating automatic forfeiture quantity, which means that even if a person is charged and pleads guilty to traffic simpliciter, if the quantity of the drug is at or over above the automatic forfeiture quantity, that could equate to an automatic forfeiture offence. So I think it's always really important, and I certainly always do, I always have a look at Schedule 2 to double check, because even with some certain fraud offences and money laundering offences, sometimes if it's under a certain quantum, it can be a Schedule 1 offence. And if it's over, it becomes an automatic forfeiture offence. Key areas for litigation. Opposing the making of the restraining order can be done, but more often than not, restraining orders are made ex parte without notice to your client to avoid or prevent the dissipation of assets. The main battleground really is exclusion applications and excluding an interest from the operation of a restraining order. You can also do the remainder things that I've listed there. Types of restraining orders. Really, there are three regimes: charge-based regime, civil forfeiture-based regime, and the unexplained wealth regime. Charge conviction-based restraining orders, from my experience, seem to be the majority of restraining orders, and potentially the easiest. I say easiest because usually it's made out on exhibiting and having knowledge of certain charges plus an interest in property or tainted property. So it's where a police officer believes, so it's a belief standard higher than a suspicion standard, that a person has been charged or will be charged or has been convicted. I pause here to say a restraining order can be made post-conviction. And that was the case that in a case I was involved in called Kohari, Kohari. And that matter actually eventually went to the Court of Appeal. A restraining order was made post-conviction over the person's home, over Mr. Kohari's home. He had pleaded guilty to cultivate commercial quantity on the basis of weight of the cannabis plants alone. I think it was 16 cannabis plants. He eventually appealed against conviction on the basis that he had, amongst other things, not been given proper advice about that intention element in relation to commercial quantity. He was successful in that, but the Court of Appeal did note that the main, having already served his 4 months imprisonment component of his sentence, he had a 4 month sentence plus a couple of years CCO. Having served that 4 months sentence, it was clear to the Court of Appeal that his main impetus for filing that appeal was in order to recover his home back so that it wouldn't be subject to the automatic forfeiture offence. And whilst the Court of Appeal was critical of the DPP for making that restraining order post-conviction, it is still permissible and it is something to be aware of. So I've set out there what the test is, but do have a look at the above provisions. Where it's a Schedule 1 offence, the restraining order can only be sought for a forfeiture order, which is a discretionary order, a pecuniary penalty order, or an order for restitution or compensation of $20,000 and over that may be made under the Sentencing Act. So it used to be $10,000 and over, it's now $20,000 and over. Those types of restraining orders are increasingly common, where there are Schedule 1 offences and property is restrained in order for its use to satisfy any restitution or compensation order that might later be made. And just a reminder that restitution or compensation orders, whilst a creature of the Sentencing Act, a criminal act, specifically become a civil judgment debt and may be enforced as a civil judgment debt, which means that a complainant or victim could obtain a warrant of seizure and sale under the county court or Supreme Court rules and potentially enforce that as against restrained property. There would need to be a variation of the restraining order, though, but that's important to know. Then we've got Schedule 2 offences, which are the offences that trigger the purpose of automatic forfeiture. And I've just set out there a reminder to be aware of the meaning of conviction, because it is upon conviction that the time for automatic forfeiture starts running, subject to some certain conditions. Have a look at Section 35. But generally, finding of guilt by a jury that day, or the arraignment and plea of guilty. It's the arraignment and plea of guilty, not necessarily what it says in the record of order later. Set out there, exclusion applications. Like I said earlier on in the piece, the time for filing exclusion applications is determined on the specific circumstance of your client. Whether or not they were given notice of this restraining order, whether it was an inter partes on notice hearing of the restraining order, what date they were served, etc. There may be extension of time of an exclusion application, provided that automatic forfeiture has not occurred, and subject to obviously other conditions. The extension of time test is whether or not it's within the interests of justice. Once there is automatic forfeiture of property to the state, the court is functus officio. It no longer has power to deal with the applications for exclusion. And it's at that point in time that you might look at other forms of relief, such as, and I've set out there, exclusion from automatic forfeiture. Now that's different to exclusion from the restraining order, automatic forfeiture, exclusion from automatic forfeiture, but an accused cannot go down that pathway. Also, there's no undue hardship relief for automatic forfeiture, like there is for most of the other restraining orders. Civil forfeiture regime. This is a suspicion-based restraining order. It's a type of restraining order that doesn't need to be founded on criminal charges and conviction. I might just give a very quick example of what that could look like. Your client's found not guilty of cultivate commercial quantity of cannabis at the residence because they were able, for whatever reason, but there's still an actual commercial quantity of cannabis that was seized from the premises. That situation could potentially fall within this type of restraining order. It requires a suspicion, being a lower standard of proof, and it's a suspicion in relation to the property itself, that the property itself is tainted property, not whether or not the person has committed a crime, but whether the property is tainted property within the meaning of the Act. And it's defined in Section 3, but it has, I think it's Section 3A, it has a different definition to other types of tainted property. And the purpose of a civil forfeiture restraining order is so that it will be available to satisfy any civil forfeiture order. This basically means that the DPP needs to take a further step in this proceeding for there to be forfeiture, as opposed to automatic forfeiture, where no further steps need to be taken, just the restraining order. If nothing happens and the person is convicted of a Schedule 2 offence, the property is gone within a certain amount of days. So once the restraining order is made, the director has 90 days to file an application for a civil forfeiture order. Otherwise, the restraining order ceases to be in force. Again, exclusion applications may be made, and the court must make the civil forfeiture order if certain procedural preconditions are satisfied. So there's no real scope for discretion there, save to say that the court can have regard to undue hardship. And the undue hardship case that's often referred to as DPP and Ali number 2. And in that case, that related to Mrs. Ali seeking exclusion of a home. And if I can recall correctly, and there were several dependents at that home, the home was not in fact returned to her. Rather, she was given a sum of money to be able to rent a property within a similar area and similar number of bedrooms. So it doesn't necessarily mean that you get the whole property back. Okay, I've got 9 minutes to quickly run through unexplained wealth. So unexplained wealth restraining orders is the third form of restraining order. At present, there are only 2 pathways. The third pathway is coming in March. So the first 2 pathways, we've got suspicion. These are all suspicions. So civil forfeiture, unexplained wealth, there need not be any criminal offence charged, convicted of whatsoever. This is on a suspicion basis and does not even require nexus to specific criminal charges or criminality. The police officer suspects on reasonable grounds that a person has engaged in serious criminal activity and has an interest in property valued at $50,000 or more. So serious criminal activity is specifically defined, and they include money laundering offences. So it's that offence, suspicion of an offence, plus an interest in property. And then the second ground is a suspicion that property is not lawfully acquired. For that second ground, and indeed for the first ground, often there are forensic accounting reports. I must say that in the unexplained wealth regime, there is more likely to be the provision of forensic accounting reports using information that has been gathered using powers under the Confiscation Act, using that information such as ATO income declared amounts. Like I said, it might include documents concerning contracts of sale obtained from conveyancers or whoever, financial documents, bank statements, all of that collated, and then an expert opinion provided by an accountant about whether or not the property is lawfully acquired. And lawfully acquired has a specific definition, a non-exhaustive definition in Section 40 capital G. So the purpose of an unexplained wealth restraining order is so that it may be available to satisfy forfeiture. And forfeiture occurs somewhat automatically, similar to the charge and the conviction-based regime, if subject to certain preconditions, of course, 6 months after the making of the order. And so one of those preconditions might be if there is an exclusion application still on foot and being litigated, that would probably stop forfeiture, would stop forfeiture. So that occurs automatically. No further step needs to be taken. Automatically, I'm saying inverted commas. All right. This is the new pathway, 6 minutes. It's due to commence on the 20th of March 2025. That is the amending act that I've set out there. From my review of the government gazettes, it does not appear to have been proclaimed earlier as yet. And a way to describe what this is is an expansion on the unexplained wealth regime. And essentially, it is the restraint and forfeiture by an unexplained wealth order of property where a person's total wealth exceeds by more than $200,000 their lawfully acquired wealth. So it's the concept of looking at the total value of someone's wealth, and wealth has a specific meaning, and looking at not lawfully acquired wealth. Apologies, and looking at what their acquired wealth is. So there are some specific definitions here that are explored in this legislation about what wealth means, what lawfully acquired wealth means, and how that is assessed. It's very new legislation. Well, it's new insofar that it hasn't commenced its operation, but it was enacted in August of last year. Wealth is defined in the Act as meaning the value of the property in which the person has an interest or otherwise is subject to their effective control, the benefits the person derives, the benefits another person derives at the direction or request of the person, the services and advantages the person obtains, or the services and advantages another person obtains at the direction or request of the person. Lawfully acquired has the same meaning in 40 capital G, and in relation to wealth referred to here, means the lawfully acquired property, lawfully derived benefits, lawfully obtained services and advantages. So that's lawfully acquired wealth. So assessment of unexplained wealth is dealt with in that provision, and I encourage you to have a look at those sections. I'm not going to read them out in full. They are very lengthy. But some things to note at this point. There are some limitations placed on these types of orders by way of needs to be at least $200,000 of unexplained wealth, and the OPP can really only go back 10 years prior to the application for this kind of unexplained wealth regime. Problematic though, because financial institutions and lawyers only have to retain documents for 6 or 7 years. So if they can go back 10 years, there will be a period of time. It's reasonably foreseeable that there will be periods of time that will be unaccounted for by reference to documents or even just a lack of memory about things that happened 10 years ago. Especially if we're dealing with the entirety of somebody's wealth and having to explain that it's lawfully acquired. It's a big job. Similar to civil forfeiture matters, an additional step needs to be taken by the DPP in order to result in forfeiture. That is, an unexplained wealth restraining order needs to be made. Then the director needs to make an application for an unexplained wealth order. That is a new concept, an unexplained wealth order. And that needs to be made within 90 days or it ceases to be in force. And the test for the determination of the unexplained wealth order is whether the respondent's wealth exceeds their lawfully acquired wealth and whether the total value of any wealth that is not lawfully acquired is $200,000 or more. Then there is the mandatory criteria that I've referred to earlier for the assessment of unexplained wealth. I just wanted to quickly draw your attention to this part, and it's subsection 6 of section 40ZAA. A respondent's wealth is presumed to have not been lawfully acquired unless the respondent satisfies the court to the contrary. So essentially, in my mind, that looks like a shifting onus to the respondent to prove the totality of the wealth, that is, the wealth described by the OPP, is lawfully acquired. The respondent doesn't need to attend the making of that order. However, if that order is not opposed, they'll run the risk of an unexplained wealth order being made against them. And finally, upon determining that question or those questions, the court can order the respondent to pay the state an amount equal to the value of the wealth that is not lawfully acquired, order a lesser amount if the court determines that it would be manifestly unfair to order the above amount, or refuse to order it on the basis that it would be manifestly unjust. So that is also the first time in the Confiscation Act that we've seen the use of manifestly unjust. There's no other reference to that concept of manifestly unjust. That'll be interesting how that plays out in the courts, how that is used to a respondent's advantage in opposing the making of an unexplained wealth order. Some key differences. It appears from my reading of the amending act that a suspect, that is the person whose wealth is suspected of not being lawfully acquired, cannot apply for an exclusion order to exclude their interest in the property. It seems that the pathway for exclusion of property, or perhaps not even using the word exclusion of property, the pathway to ensure a judgment debt is not ordered against you is to defend the making of the unexplained wealth order. Also, like I said before, we've got this introduction of manifest unjustness. So that is the test for a third party. For example, let's say you've got a wife and husband. That's a silly example. Let's say there are two co-owners of a property. One person, though, is the sole registered proprietor. The other person has an interest arising by way of a resulting trust because they advance the totality of the deposit. They are not registered on title. That third party would then need to go down, it seems, the exclusion route and prove that the property was lawfully acquired. Whether that means they have to prove the totality of the property, much of which they would have no knowledge about, or could they simply assert that it would be manifestly unjust if they could prove that their deposit came from lawful funds to restrain the property that they'd got an interest in. Other matters, just to quickly note about this regime, an unexplained wealth order is a debt due to the Crown and it may be enforced as a civil judgment debt, not dissimilar to the compensation and restitution orders under the Sentencing Act. Payment of the order is due within 90 days or otherwise as ordered by the court. Forfeiture of restrained property occurs if there is non-payment by that date. And once you've paid, the court can set aside the order. So that's an interesting way of dealing with it, that it's a debt due to the Crown. A question here is, what happens if the unexplained wealth order is in the amount of $1 million and the property is only worth $800,000? You've still got $200,000 outstanding on the unexplained wealth order. So that's just something to note. There is a relief from debt imposed, and this might be the certain situation where you would seek relief from the debt imposed by the unexplained wealth order if the restraining order property wasn't enough to cover the debt and you'd otherwise be left destitute. Okay. I've been very, very quick there. Does anybody have any questions?
I think we've got a question there in the chat. We'll just bring that up. Bill Duke has asked, thanks. He's just said, thanks, Abby, for your presentation. You talked about the key areas of litigation. Which area do you find has the most, if any, success for suspects specifically? I think you talked about opposing the making of the restraining order, exclusion applications, or varying, setting aside, or just relief from forfeiture.
I think what most practitioners would say the battleground would be exclusion applications. And the exclusion tests differ depending on which regime you're in and whether or not you're the accused and whether or not the property itself is tainted or derived property. So exclusion applications, I'd say.
Mm-hmm. And segueing right into what will be our topic next time, which is on the 18th of March. And I think you mentioned that your colleague Eli Fryer, also a barrister, will be speaking on that date about applications under the Confiscations Act, maximising an applicant's chances of extending time to file an exclusion application, staying an exclusion application, succeeding in an exclusion application. He'll also touch on varying restraining orders and hardship applications. That's on the next occasion. We've just had another question come through from Cosette. When opposing an unexplained wealth order, are there any steps our clients can take or types of evidence we could recommend that they gather in an order if an order is sought for offending that is 7 to 10 years after the fact? So archived documents might be an issue.
Yeah, that's a good question. What do you do about that 7 to 10 year period? I'm not sure. Other than to say that it seems that for unexplained wealth orders, forensic accounting reports, if they can be afforded, ought be obtained, I think. It might become some kind of battle of the forensic accountants, and we might see kind of civil procedures like hot tubbing, where forensic accountant experts or any experts get together and go through their respective reports, or where there's a mutual report prepared for the purposes of the court. That might become more common in these unexplained wealth order matters.
Absolutely, that makes sense. All right, so without any other questions, I'll say thank you very much to Abilene. It's been really informative talk, and particularly on those new areas in relation to unexplained wealth. Thank you for joining us. We'll see you all on the 18th of March for our next talk. Have a lovely evening.
Thank you, everybody.
Thank you.